This is Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multi-asset and multinational hedge fund. By multi-asset, I mean we actively covering our positions in multiple asset classes. By multinational, I mean we actively covering positions in multiple locations. But like I repeated many a times, and I would continue to repeat in my all videos that we are a proprietary hedge fund. The technical definition of proprietary is that no third party, I repeat, no third party can invest capital in our funds. Please take a note of that. Today, my deliberations would be as a hedge fund manager, as a finance professional, as a ex-corporate treasurer, and alongside as a LLB student, as a law person. I promised you that I would be evaluating the judgment on Yes Bank. By evaluation, I mean to say I would be reading the complete deliberations of prosecution side, and I would be reading the complete deliberation of defense side, and I would be linking both with the legal framework we have in India. But before I initiate, I once again thank you to Honorable Mumbai High Court for giving a fantastic judgment as far as the Yes Bank AT1 bond is concerned. I really thankful to Honorable High Court that we set a very high standard in the judiciary that regulator is not supposed to take any action which is violating the public interest and ends up losing the money for the public. But the way I'm reading this judgment is completely different, and that is my way. So first of all, before reading this whole judgment, I read this book once again thoroughly. Now this is a book on the Yes Bank, which is on Rana Kapoor. I bought this book from Amazon as always, and I read this on line basis, and you can see that my notes, the yellow color, you can also see that this sticks which I made, the important points which I made. So first I read this book thoroughly because this book is nothing but the history how Yes Bank incorporated, how Rana Kapoor got the control of the Yes Bank. Unfortunately, the founder of Yes Bank, what had happened with him. Unfortunately, the daughter and the wife of the co-founder, they went through the severe pain to get their rights, and the Diwan housing and many more issues which are mentioned in this book. So before reading the judgment, it was almost pertinent for me to read this book again, which I did, which took me 5 days because I read this book thoroughly, make a notes, because now I can easily say that there is a big flip side we are having as far as Section 35A of Indian Banking Regulation Act 1949 is concerned. Now, after reading the book, what I did, I went to the Bare Act of Indian Banking Regulation Act. You can see that this is a Bare Act of Indian Banking Regulation Act. If you are not a law person, then for you, the Bare Act means a concise note. Basically, the Bare Act only covers the sections. Sometimes they cover the commentary, sometimes they do not cover the commentary, but they cover the sections. And if you take the commentary, which is volume, sometimes in 1 volume, sometimes in 2 volume, like the CRPC I'm holding, it is in 4 volume. IPC books are also available. Indian Penal Code, they are in 5 volume also. So they are very detailed book actually. You will get the minutest piece about the law in these detailed books. But once again, they are costly and you need to read them thoroughly, which consumes a huge quantity of time. So this is a bare act. This is quick reference. We can easily get the reference. Yes. If we have any interpretation issue, we go to Google, we search the topic, we see how Honorable Supreme Court, Honorable High Courts gave their verdict on that, what is their stance on this, so on and so forth. And then I did the three things. Number one, I took the print of the final Yes Bank Reconstruction Scheme 2020. This is published 13th March 2020. So this is the Yes Bank Reconstruction Scheme 2020 final, and this is published on 13th March 2020. And then I took the draft from the RBI website, and this draft is published on 6th March 2020, which means around a week before the final, which means the first it was draft and then it is final. There are a few differences which we have between draft and the final, and the prosecution stressed on that differences, although I tend to differ a bit on that, but still. Then I went to Google and I checked that Banking Regulation Amendment Bill 2020. Banking Regulation Amendment Bill 2020, which means the amendment, the Banking Regulation Act of 1949 is amended in 2020, which means it is the same period when, the corona and all these things had happened. Now in this, I am yet to read this, but I am hoping that there must be certain changes which I am looking forward. And then finally, the judgment copy delivered by the Honorable Court. You can easily see that I print out the judgment copy from the internet, and then I took the spiral of that so that I can use this for a longer period of time. And I intend to hold this judgment copy for a very longer period of time. I already told people that I would be reading this judgment provided by the Honorable Court at least 10 times. At least 10 times, because I wanted to even pinpoint, I mean to say, even to see the minutest piece of what the prosecution said and what the defense said. By prosecution, I mean the party, and the defense, generally Reserve Bank of India and all. But this judgment is a sum of many writ petitions, interim applications which are filed before the Honorable Court. And if you look at the first few pages, then Honorable Court even referred the name of writ petitions also. They also mentioned that who is the petitioner and who is the respondent, in this sense, who is the plaintiff and who is on the defense side. There are many writ petitions, application in person, written applications which being filed. Now this is around 81 pages, you can say, this judgment, and I am currently at 35th page. I even made my notes also like this, which is over and above the print content which I'm having. This is what I would be doing. Now, when I read this, the prosecution piece, the prosecution is thoroughly relying on Section 35 of the Banking Regulation Act 1949. Now, let me first read few things what prosecution has said. The exercise of the power to write down the bonds is a statutory power exercised in public interest under the provisions of Section 35A and 45 of the Act. Act means Banking Regulation Act 1949. Read with Basel III compliant regulation. The writing down of AT1 means additional tier 1. The writing down of AT1 bonds is an exercise of statutory powers under Section 45 of the Act 1949, read with the clause 2.15 of Master Circular. Okay, I completely I read this, Then what I did, I went to the Bear Act. And in this, I went to the 35th article, on which the prosecution is, putting a stress. Now, when I went to 35 and especially the 35A, on which the prosecution is making lot of stress, I read this again and I got something which, unfortunately, as we speak, till 30th page I read, I not saw mentioned by the prosecution. Probably I don't have the copy of the petition, which is also known as the counter affidavit, which is probably the petitioner might have filed the affidavit. RBI might have filed the counter affidavit, or you can say their reply in this part. Then the honorable court would go with both the documents, and then you have an argument in place. Now, if I go with the Bear Act, then 35A reads like that. Where the Reserve Bank is satisfied that, point number A, in the public interest, or point number AA, in the interest of banking policy, or point number B, to prevent the affairs of any banking company being conducted in a manner detrimental to the interest of depositor, or in a manner prejudicial to the interest of banking company, or point number C, to secure the proper management of any banking company generally. It is necessary to issue direction to the banking companies generally, or to any banking company in particular. It may from time to time issue such directions as it deemed fit, and the banking companies or the banking company, as the case may be, shall be bound to comply with such directions. Now, first of all, before I move further, I have a huge reservation from here, but I'm holding myself. Point number 2 is the Reserve Bank of India on representation made it to, or on its own motion. Please take a note, on its own motion, modify or cancel any direction issued under subsection 1, and in so modifying or cancelling the direction may impose such condition as it thinks fit, subject to modification or cancellation shall have effect. Now, what it's saying that Reserve Bank of India have a power to give directions, which is in public interest, in the interest of banking policy, in the interest to prevent the affairs of banking company for being prejudicial, to secure the proper management of any banking company. And point number 2, Reserve Bank of India, whether on representation made or on its own motion, which is called Moto. Now, a bare reading is proving a point that Reserve Bank of India can take Moto. And Reserve Bank is nothing but the central bank of the country. When appellate courts, appellate tribunals, and everyone have their respective powers, RBI can also take Moto. Now, it does raises a very big point, and unfortunately speaking, till 31st page I've been to, out of 81 pages judgment, I am unable to get the word which I'm seeking, which is called the Moto. Now, why I'm bringing Moto into the picture, which is that, now this book tell you that how Yes Bank incorporated, how Rana Kapoor got the control of the Yes Bank. Unfortunately, what had happened with the co-founder, and after co-founder, how Rana Kapoor was the only face of the Yes Bank. And how come he hired so many people, the role of divan housing, infrastructure leasing, and so many things, the media also, which is mentioned in this book. But unfortunately, this book is outrightly silent on the auditor of the Yes Bank. And I'm not sure why this book is silent on the auditor of the Yes Bank. My point is, if RBI can take a suo moto on its own motion, right, then what was pushing RBI not to take suo moto when these things were happening in the banking? Now, guys, here you will get to know. In fact, Rana Kapoor was not the first founder of Yes Bank. Someone else was the founder of the Yes Bank. Then somehow, things had changed, and then Rana Kapoor entered into the picture. Point is, when all these things were happening, when Yes Bank non-performing issues were going on, when Yes Bank made so many companies, when Yes Bank had an interaction with the media, when Rana Kapoor was the only face of the Yes Bank, when Yes Bank was lending aggressively in the market, everything is mentioned in this book. Then why RBI not took the suo moto? That is the only point I would like to raise. Like I said, I'm really thankful to the Honorable Court, and I would be reading this judgment at least 10 times. So I would be making a lot of points in the near future. But today I read the first point, which is section 35A. You know why I spell article? Because when you read Constitution, you get a habit of speaking article actually. So it's very difficult to shift from article to section and then section to article, but I'm trying. So in 35A, it's all about the suo moto. That's more important thing. And very important thing is that, please note the word, in the public interest, in the interest of banking policy, to prevent affairs of any banking company being conducted in a manner detrimental to the interest of the depositor, or in a manner prejudicial to the interest of banking company. Please use the word public interest, banking policy, detrimental. These words indicate that RBI can easily take suo moto cognizance. There is no need of the representation which is being made to the Reserve Bank of India. They can easily take suo moto cognizance. Now, my point is, with a humble request to the prosecution, is that did we stressed on this part before the court? I'm not aware about that, because like I said, I don't have the copy of the petition. Copy of the petition is with the Honorable Court. It is the prosecution who would have submitted the copy to the court. The defense might have submitted their copy to the court. I don't have the copy, but one thing which, the reading I got to know is that the suo moto piece is not there in the document which I received. This is one thing. Another important thing which I would like to highlight, and that really, I don't want you to use, that really confused me actually. That really confused me, that, I would say that in law, there are interpretation can be divided into two parts. Number one is called grammatical interpretation, and number two is called logical interpretation. Now, the Baer Act, which I studied before you, now the 35A, what I mentioned, is grammatical interpretation. One is called logical interpretation, which means beyond convention, read between the lines. This is called logical interpretation. You read any law of any country, then it's only have grammatical interpretation and logical interpretation. And a right law person is one who understands both, and it is mandatory. Now, first of all, what confused me is that I went to the draft guidelines of Reserve Bank of India, which they uploaded in the public on 6th March 2020. Now, this is the time when Corona and all these things were going across the globe. I went to point number 6. Now, that point number 6 I can show you. Now, in this point number 6, the title is Right and Liabilities of the Reconstructed Bank. Okay. And I went to point number 2. So, technically 6, subsection 2. All deposits with the liabilities of the reconstructed bank except as provided in the scheme and rights, liabilities, obligation of its creditors will continue in the same manner with the same terms and conditions completely unaffected by this scheme. Which means that when this scheme implemented, draft 6th March 2020, everything, liabilities, rights and obligations of the creditors would continue, technically speaking, intact, we can use. Then I went to the final scheme, final scheme, point number 6. I went to point number 6 and I got almost the same line, which is all the deposits with the liabilities of the reconstructed bank except as provided in this scheme, and the right and the liabilities and the obligations of its creditors shall continue in the same manner with the same term and the conditions completely unaffected by this scheme. It means RBI is in agreement, even in the draft way or in the final way, that AT1 bonds would continue to be what it was. But having said that, I not raised a very pertinent point, which is the debenture trust deed, which is alternatively known as indenture. In our parlance, which is known as AT1 documentation. That is another beautiful thing, because AT1 belongs to a family of COCO. COCO means contingent convertibles. If you visit Amazon, if you get some time, you would be able to see that there are books which are written on AT1, on these instruments. Henceforth, AT1 is nothing but a breed of COCO, which is contingent convertibles. And if you go to the final report of European banks, probably American banks also, which is known as 10K, you would be able to see that they mentioned COCO, which is contingent convertibles. Even if you search internet, Google, you would see UBS COCO, Credit Suisse COCO, and all this. You will get a lot of information from the market. Although I not been through this document completely, so I am not making any comment, but yes, once I am going to be done with this documentation, I am really wishing I will get the COCO, which is contingent convertible. But having said that, like I promised you, I would be covering the Yes Bank judgment in detail, since this falls in my interest, both interest, one is banking and one is law. And thanks to my reading habit, because of this book, I got so much information which I doubt even I had to take a lot of print from the internet, and then I might not be able to get what I got in this book, except the auditor piece. But that's okay, I understand. But yes, under 35A, Indian Banking Regulation Act 1949, I'm not done with the amendment 2020, so I will strictly restrict myself to Indian Banking Regulation Act 1949. RBI can do suo moto. Now, if RBI can do suo moto, then why RBI was waiting when all these things were happening? What pushed RBI not to take suo moto against Yes Bank? And guys, if you read this book, like I'll tell you, let me study one line from you. Yes, page number 125. I released ICICI Bank and Axis Bank were the two large private banks that were hit hard by the review. At ICICI Bank, the difference in gross NPA to the tune of 5105 crore, lending to an additional provisioning of 1071 crore in 2016. At Axis Bank, the RBI had found a gross NPA divergence of 9478 crore, raising its bad loans to the prior fiscal year to 15,566 crores. The AQR, asset quality review, the AQR would also uncover chinks in the Yes Bank armor. Yes Bank annual report for 2016 showed that in their assessment of the bad loans in the previous fiscal year varied from that of the RBI. Please take a note. It discloses a gross NPA. It had discloses gross NPA of 749 crores approximately, but RBI assessment is 7 times, which is 5,000 crores. Please take this book. None of the words from my side. Not a single word is from my side. Everything what I read is from the book. You can also see that the yellow color mark, because when I'm reading the book and I'm finding something appropriate, something very important to learn, something very important to remember, I mark them using a highlighter so that I need not to waste the time when I'm going to be reading again. It means for the annual report 2016, Yes Bank said they are having gross NPA of around 749 crores as per this book, while RBI assessment was approximately 5,000 crores, which means approximately 7 times. Then why RBI not took the Moto cognizance at that point of time? Why section 35A was not invoked at that point of time? But section 35A was invoked when Yes Bank collapsed. Then it is invoked. But section 35A not invoked when these things were happening. Guys, please take a note that what I read at page number 125 of this book, this is just a demo. If you read this book, you would be thankful to the author, Mr. Pawan C. Lal sir, that he mentioned many things about the Yes Bank. In fact, he also mentioned how media played its role, with Yes Bank. And it does raises a very big question after reading this book. Then section 35A, Indian Banking Regulation Act, Moto, why Moto was not taken at that point of time. That's a very, very important thing which I would like to raise in my part 1. I cannot cover everything in one video. It's beyond my time limit. I need 2 months to went through the whole judgment. And fortunately, I'm very fortunate and thankful to the Mumbai High Court that they also mentioned their reliance. Basically, the prosecution also mentioned their reliance on one more judgment, and court mentioned this in their judgment, which is Piyush Bokaria and others versus Reserve Bank of India and other. This judgment is Supreme Court 2020. SCC Supreme Court case online Madras 2693. And that's very important. I downloaded the judgment copy. Now this judgment is by the division bench of Honorable Madras High Court. So what is saying? Reliance is placed on the judgment of the division bench of the Madras High Court in the case Piyush Pokaria and others versus Reserve Bank of India. And I'm thankful to Honorable Madras Court, Honorable Mumbai High Court for mentioning this, because this is again around 90 pager judgment, around, you can say. And I'm going to be printing this also to see that how this judgment interlinks with this judgment. It's a very complicated case actually. You need to be through each and every aspect, which is not at all easy. But yes, one thing is very clear to me, that under 35A, RBI can easily take suo moto. And when RBI can take suo moto, then why suo moto was not taken when these things were going inside the picture? And it's not one instance. There are various instances you will get to know while reading this book, which is barely, it's an affordable book. Everyone can afford that book. If you read this book, you will get to know there are several instances where suo moto cognizance can easily be taken. Had it been the collapse happened in Indian banking in 2020 could have easily been avoided if the suo moto cognizance taken at a right point of time. This is the part one of the Yes Bank case. At the end, my sincere thanks to the Madras High Court for giving this judgment, which Honorable Bombay High Court also mentioned in their holistic judgment, complete judgment. My sincere thanks to the author of the books, Mr. Pawan C. Lal, for making a wonderful book, because in just few hundred rupees you got so much knowledge for which you might be able to spare probably a couple of years on the internet, print several hundred papers, and then you're not sure you will get that information. I thank you to many articles which I downloaded from the internet, which I'm not disclosing now. I would be disclosing in the later stages once I would be ready with the part 2. But yes, one thing is very clear, that suo moto was possible. That's it. And guys, even today, with due respect, you know how the banking is going on. I would like to wind up my deliberations that, around a year or so, Indian media barely talking about the asset quality of Indian banks. Barely talking about asset quality of Indian banks. Rather, I strongly believe that for what reasons Institute of Chartered Accountant of India, alongside Ministry of Corporate Affairs and other bodies, are not pushing ECL, expected credit losses, as a mandatory provision for Indian banks. I don't understand why it is not happening. I fail to understand, let it be honest. But having said that, the information which came in the public domain, which said that in the last 5 financial years, around 10 lakh crores worth of non-performing assets being wrought off. 10 lakh crore. And it's a huge amount, to be honest. It's a huge amount to me. It's not a small amount. This 10 lakh crore is a taxpayer money. I don't know the formula of asset quality review by RBI, but having said that, this 10 lakh crore which is being wrought off, how much would get recovered? I am doing my research. This is what I can say. Thank you very much. This is Rahul Magan from Treasury Consulting Group. You knew my personal number, +91 98 99 242 978. +91 98 99 242 978. In case of more information, you can visit our fixed income platform, www.fixedincome.global. www.fixedincome.global. Thank you very much and have a great time ahead.